All right, let's start with some breaking inputs which have just come in, where the Supreme Court of India has quashed a law passed by the State Assembly in the North Indian state of Uttar Pradesh, granting permanent residential accommodation to former chief ministers. Now, the apex court said that such facility cannot be extended once they demit office. All right, now this is an interesting bit of a legislation that's been quashed, where the Supreme Court of India has decided to quash a law that was passed by the State Assembly in the state of Uttar Pradesh in India, which granted permanent residential accommodation to former chief ministers. Now, it's interesting that a chief minister should, even after his tenure is over, should seek for a government accommodation, and now the Supreme Court has said that such facility cannot be extended once the person demits office. It'll be interesting to see whether the Uttar Pradesh government now will be challenging this order of the Supreme Court, whether they would ask the Supreme Court to review this particular quashing that has been done by the Supreme Court in terms of a law that was passed in the Uttar Pradesh Assembly, which sought to provide accommodation for a chief minister even after he or she were to demit office. Why should a chief minister seek the government to actually provide official accommodation of sorts even after his tenure is over and after he has demitted office? Now, this is something that was up for question. This was a law that was passed in the Uttar Pradesh State Assembly. This was challenged in the Supreme Court, and in a landmark ruling, the Supreme Court has said that the state exchequer cannot be burdened with providing an official residence for a chief minister whose term is over. So the Supreme Court has thrown out the law that was passed by the Uttar Pradesh Legislative Assembly. This of course, will be a big blow for the Uttar Pradesh government, which was hoping that chief ministers, once they demit office, will be able to stay on in official bungalows which will be supported by the public exchequer. But the Supreme Court has said that that is not to be done, and it has, in its wisdom, decided to quash this particular law. So no official residence will be provided for ex-chief ministers of a state, as was being sought to be done in the state of Uttar Pradesh. So the Supreme Court of India has quashed a law passed by the State Assembly in the North Indian state of Uttar Pradesh, granting permanent residential accommodation to former chief ministers. Now, the apex court has said that such a facility cannot be extended once they demit office. So no official residence for ex-chief ministers. This is what the Supreme Court has in fact in its wisdom said. It has decided that a law that had in fact been passed by the Uttar Pradesh State Assembly cannot actually be in the interests of the people. The Uttar Pradesh Legislative Assembly, in its wisdom, had decided that chief ministers, even after they demit office, should be allowed to live on in bungalows that would in fact be funded by the exchequer. But the Supreme Court has decided otherwise, and it has, in its wisdom, said that that is not going to happen. It has thrown out the law that was passed by the Uttar Pradesh Legislative Assembly, stating that such a law is not something which is in the interests of the people at large, and there is no reason as to why the public exchequer, the people of India who pay taxes, the hard-working people of India, should be footing the bill for a former chief minister of a state to continue to live on in a government bungalow. All right, now for more on this, we are joined in by our correspondent Jessica Taneja. Jessica, what's the latest on the story?
Well, Mohammed, the fact that this law has been put aside, the UP government law that was passed in the year 2014 and then again reiterated in the year 2016, which allowed ex-chief ministers to retain their bungalow, which according to the amicus, Gopal Subramaniam, when he had submitted this report to the apex court, had said categorically that it cost a lot of money to the exchequer, and that once the public officers have been demitted, it doesn't make sense that the ex-chief ministers retain that bungalow, because the maintenance cost and everything really goes up and again it goes away from the government coffers then.
Absolutely, indeed. And Jessica, have you heard anything at all from the Uttar Pradesh government? Because it is an interesting sort of a thing that a former chief minister would expect that the public exchequer would foot the bill for the bungalow post his tenure is over. Is the Uttar Pradesh government planning to perhaps file for a review petition of sorts?
Well, of course, the Uttar Pradesh government will be moving forward and challenging this order like they did earlier as well, because a bench, comprising of Justice R. Bhanumati already had, set aside this law in the year 2016. That is when the UP government came back and took a review of this order. And yet again, another Supreme Court bench of the, recently, I mean, it's very recent, Mohammed, because it was in the year 2016 when that judgment had come out, which had quashed the law, which had said that, money cannot be spent on refurbishing bungalows for ex-chief ministers. So again, it was challenged, and again, another Supreme Court bench has in fact said that this law has to be put aside. And also, Mohammed, we should remember that this judgment sets another benchmark, because it might also now be read carefully for other states. It won't just be limited to Uttar Pradesh, but other states as well, where ex-chief ministers, even considering ex-prime ministers and ex-presidents, who will fall in the ambit now.
Absolutely indeed, Jessica. Some very interesting implications of this judgment. We'll have to leave it there. Thank you very much indeed for joining us and getting us all those updates then.